All right, so let's jump into this patent battle.
Yeah.
You sent us a whole bunch of documents about Philips. Philips, the electronics giant,
The Viblips.
going up against 3 Indian DVD companies.
Yeah.
Pearl Engineering, Siddharth Optical, and PowerCube Infotech.
Wow.
Philips is saying these companies are using their patented DVD tech without a license,
Right.
and they are not happy about it.
No.
So we're going to break down this case, figure out what each side is saying,
Okay.
and see how the court ruled.
Sounds fascinating. It's really interesting to see how technology, business, and law all kind of come together, especially in a global world like ours.
Yeah, exactly.
Yeah.
So let's start with the core of it all.
Okay.
Indian patent number 218255,
All right.
held by Philips.
Okay.
It's about a type of coding called EFM+,
Right.
which is really important for getting more data on DVDs.
Yeah, and that's actually a really key point. EFM Plus is part of the DVD standard.
Okay.
It's the rules that make sure any DVD will play on any DVD player, regardless of who made it. So this isn't just some, small patent.
Right.
This is foundational to how DVDs work.
Okay, so Philips is arguing that these companies are making DVDs with their EFM Plus tech
Right.
without permission.
Yes.
And they say, hey, we had a fair licensing program available, a FRAN program,
Right, yeah.
but these companies didn't sign up.
Which is interesting because then that brings us to the company's defenses.
Okay.
And they came out swinging. They really questioned the validity of Philips' patent.
Okay.
They argued that it wasn't new or innovative enough to even be patented.
Interesting.
And they claimed that a Sony patent already covered similar ground.
So they brought up this idea of prior art
Exactly.
to say that Philips's invention wasn't original.
Right. They were saying, look, this is old news.
Okay, but wasn't that their only argument?
No, they had another one.
Mhm.
They also argued that their DVD replication process was purely mechanical.
What do you mean?
They were basically saying, look, we're just stamping out copies from discs that already exist.
Hmm.
We're not doing the encoding ourselves.
So they're saying, hey, we're not infringing because we didn't mess with the data.
Exactly.
We just made physical copies.
Right.
Clever. Did the court agree?
Not really.
Why not?
Well, to understand that, we need to look at the court's reasoning.
Okay.
They looked at Philips's patent claims
Mm-hmm.
and pointed out that some claims focused on the encoding process,
Okay.
but others were about the final DVD itself,
Okay.
regardless of how it was made.
Oh, so the court is saying it doesn't matter if you just pressed a button to make copies.
Right.
The DVDs you made still have our patented technology.
Exactly.
So you're infringing.
That's what they ruled.
Okay, so it's not just about who does the encoding.
It's about the final product.
It's about who makes it, who sells it, who distributes a product that has that patented tech.
It's the whole chain.
Got it. What about the defendants trying to blame Moser Behr?
Oh, yeah, that's interesting.
They said they got their stampers
Uh-huh.
from this Philips partner.
Right, a license partner.
Yeah, so it's not their fault.
Right, like we were just borrowing the car.
Exactly.
Did that work?
Not at all. The court looked at the evidence and said Moser Behr's license with Philips didn't allow them to give stampers to other people for unauthorized copying.
So they were trying to find a loophole in the agreement.
Yeah, it seems like it.
And the court said, nope.
And nope. And that brings up a bigger point about intellectual property law. You can't just assume because someone else has a license, you can piggyback on it.
Right.
You've got to look at the details of those agreements.
The details matter.
They really do.
Okay, so we talked about the technical arguments, some legal maneuvering,
Yeah.
but let's talk about the consequences. What happened to these companies?
Well, the court basically sided with Philips on almost everything.
Wow.
They looked at each defense, really carefully debunked those claims of prior art,
Okay.
and they upheld that Philips' patent was valid. But there's a bit of a twist.
The twist. What do you mean?
While the case was going on, and it went on for years, Philips' patent actually expired. Wait, hold on. If the patent expired, isn't the case over?
Well,
if it's not protected anymore, why are they suing?
that's where it gets interesting legally.
Okay.
So Philips couldn't stop the companies from continuing to make DVDs.
Right, because the patent's expired.
Exactly.
Yeah.
But they could still go after them for money.
For the time they were infringing.
Exactly.
Okay, that makes sense. But how do you calculate damages in a case like this?
That's a great question, especially because the companies weren't exactly transparent with their records.
Right, they weren't playing nice.
Yeah. So the court had to get creative.
Mm-hmm.
They used available sales data industry standard royalty rates for DVD patents.
Okay.
And here's the key. They made adverse inferences against the companies.
What does that mean?
It means because the companies were hiding information and not cooperating, the court said, okay, we're going to assume the worst.
Oh,
They filled in the gaps with assumptions that weren't good for the companies.
ouch. So that's a penalty for not playing by the rules.
Exactly. The court awarded Philips over 6 crore rupees from Pearl Engineering, over 1 crore from Siddharth Optical,
Wow.
and a big 12 crore from PowerCube Infotech.
Those are some serious fines.
Yeah. It shows that there are real consequences for trying to skirt the law.
And that being honest with the court is probably a good idea.
Transparency is key.
Okay, so this wasn't just about money though, right?
You're right. The court also talked about this idea of the unwilling licensee.
The unwilling licensee?
Yeah.
What is that?
It means you can't just ignore someone's patent and say, I didn't know. You can't just use their technology without permission.
Right.
The court made it clear, if you're using a patent, you need to get a license, make a deal, or find another way to do things legally.
So no hiding behind ignorance.
Nope. The court wasn't having it. And this case sets a precedent.
Interesting. So we've gone through the technical stuff, the legal stuff.
Now, we've covered a lot.
But there's more to this story, right?
There is. We need to look at the bigger picture.
Okay, wait, what?
Like the ethical questions, the global trade issues, even the future of the DVD industry.
Okay, now I'm really interested.
Yeah, it gets pretty deep.
Let's dive into all of that next time, then.
Sounds good. Okay, so let's break down this whole DVD replication process.
Yeah, let's do that.
So it starts with a master disk, right, where
sure.
all the data is encoded, like your movie, your software, whatever.
Using that EFM Plus technology we talked about.
Exactly. EFM Plus is key here.
Okay, so the master disk is like the original...
See the blueprint.
Yeah, blueprint.
And then from that master, you create a stamper,
Okay.
which is a metal disc. It's like a negative image with all the data etched onto it.
Okay.
And the defendants, they took these stampers and used them to make the final DVDs.
So they were saying we just made copies from pre-existing stamper.
Right.
We weren't involved in the encoding.
Yeah, that's their argument.
So we shouldn't be liable.
That's what they're saying.
Okay, but the court looked deeper.
Right? Yeah, they did. They looked at the specific claims in Philips' patent, and some claims focused on the encoding,
Okay.
but others were about the final DVD,
Right, the DVD itself.
regardless of how it was made.
So the court is saying it doesn't matter if you just pressed a button.
It doesn't matter.
The DVDs you made still use our technology.
They do.
So you're infringing.
You got it.
Interesting. So it's not just about the encoding.
No.
It's about who produces the final product.
Exactly.
Got it. It's like saying, I didn't write that book,
Uh-huh.
but I printed and bound the copies.
The analogy.
So I'm
Yeah.
not infringing.
The court saw right through that.
Okay, what about that whole Moser-Behr thing?
Yeah.
They said they got their stampers from Moser-Behr.
A licensed Philips partner.
Right, so it's not their fault.
Yeah, but the court said no.
Why not?
Because Moser-Behr's license didn't allow them to give stampers to other companies for this kind of unauthorized DVD replication.
So Moser-Behr couldn't just share those stampers.
Not for this purpose, no.
So the defendants were trying to exploit a loophole,
It seems like it.
and the court shut it down.
They did. And it's a good reminder that you can't just assume you can use someone else's license.
Right.
You have to look at the specifics of the agreements.
Okay, so we've talked about the technical stuff, the replication process, but what was the final outcome?
The court sided with Philips.
On almost every count.
Yeah, they really broke down each defense.
Okay.
They said the prior art arguments didn't hold up, and they upheld the patent.
But there's a twist, right?
There is a twist. While all this was happening, the case was going on.
Yeah, it took years.
Philips' patent actually expired.
Wait, so if the patent expired,
Yeah.
how did the case continue?
It gets a little tricky legally.
Okay.
Philips couldn't get an injunction.
To stop them from making DVDs.
Right, because the patent wasn't active anymore, but they could still get monetary damages.
Oh, so they could still go after them for the period of infringement.
Yeah, for the time they were breaking the rules.
Okay, so how do they calculate damages in a situation like this?
Especially when the companies weren't being transparent.
Right, they weren't exactly cooperative.
Exactly. So the court used the sales data. They looked at industry standard royalty rates,
Yeah.
and they made adverse inferences against the companies.
Adverse inferences. Again, what's that?
Basically because the companies weren't being honest.
Yeah.
The court said, we're going to assume the worst.
Ah.
And they calculated damages based on those assumptions.
So they got penalized for not cooperating.
They did. They really did. The court awarded Philips a lot of money.
How much?
Over 6 crore rupees from Pearl Engineering,
6 crore rupee.
Over 1 crore from Siddharth Optical.
Wow.
And a big 12 crore from PowerCube Infotech.
Those are some hefty fines.
They are. It shows you can't just ignore intellectual property law. There are consequences.
So the court was sending a message.
They were.
Don't mess with patents.
And be transparent.
Be transparent.
Honesty matters.
It seems like this case was about more than just money, though, right?
You're right. It also touched on this concept of the unwilling licensee.
The unwilling licensee.
Right. Basically, the court is saying you can't just pretend you don't know about a patent.
You can't just use technology without permission.
You can't. You need a license. You need an agreement.
You need to do things the right way.
Exactly.
Okay, so we've gone through the technical arguments, the process, the court's decision.
Yeah.
But you mentioned some bigger implications too, right?
Yeah. There are some broader things to think about.
Like what?
Like the ethical questions around all of this.
Okay.
The global trade issues, even the future of the DVD industry.
Okay, now I'm really intrigued. Let's talk about all of that in the next part.
Let's do it.
So we talked about the technical details,
Right.
the legal arguments,
Low courts.
the court's decision.
Yeah, we really went through it.
But you said there were some bigger implications too.
Right, like the ethical questions.
Yeah, that's what I'm really interested in.
It's a tricky area.
So on one hand, you have companies like Philips investing a lot in research and development.
Right.
They deserve to be rewarded for that.
They do. It's their intellectual property.
And they have the right to protect their inventions.
Exactly. That's what patents are for.
But then there's also the issue of making sure these technologies are accessible
Right.
and affordable for everyone.
Especially with something like DVDs.
Right. DVDs became like a standard
Yeah, for movies, for soft
for
drama.
everything. Imagine if only a few companies could make DVDs
Uh-huh.
because of these patents.
It would be a monopoly.
The cost of everything would go way up,
It would hurt consumers.
and all the industries that use DVDs.
So it's a balance.
Right.
You want to protect innovation, but you also want to make sure technology is accessible.
It's tricky.
It really is.
This case also makes me think about the power dynamics.
Yeah.
You have this huge company, Philips,
A multinational giant.
going after these smaller DVD companies in India. It almost feels like they're using their power to stifle competition.
That's a valid point. And it's something that comes up a lot with patent law.
Like with those patent trolls,
Yeah.
they just buy patents to sue people.
They're not really innovating.
They're just looking for a payday.
It's a controversial area.
So even though Philips does make products,
They do.
some people might say they were being too aggressive in this case.
That's a fair argument.
Maybe they were trying to control the market.
It's hard to say for sure.
It makes you think about the role of patents.
It does. Are they supposed to just protect inventions?
Or are they a way to gain an advantage?
It's a complex issue.
What about the global trade side of things?
Oh, yeah, that's interesting too.
You have a Dutch company suing Indian companies.
Over an Indian patent.
It's a very international case.
It is, and it shows how patent law is becoming more and more global.
Companies are doing business all over the world,
Right.
so these disputes can happen anywhere.
And the laws are different in every country.
It sounds like a headache.
It can be very complicated.
And expensive.
Patent lawsuits can drag on for years.
They can, and this one did.
It did, which makes me think about the whole DVD industry.
Yeah.
DVDs aren't as popular as they used to be.
Everyone's streaming now?
Exactly. So it's almost like this fight was over a shrinking market.
Right.
Yeah.
Like, who cares who wins if no one's buying DVDs anymore?
But the legal principles are still important.
Okay.
They could apply to other technologies.
That use similar data storage methods.
Right.
So even though DVDs are fading away, the impact of this case could be felt elsewhere.
It could. It could set a precedent.
What about those delaying tactics we talked about?
Oh, yeah, the defendants trying to hide information.
It seems like that really backfired.
It did. The court didn't like it.
And it affected the damages they had to pay.
So it's a good lesson.
Be honest with the court.
Yeah, transparency is key.
So what are the big takeaways here?
Well, this case was about DVDs, but it raises questions about innovation,
About access to technology?
about global trade.
About how companies use patents.
It's a reminder that patent law is really complex.
And constantly evolving.
And it affects everyone.
So we've learned about DVD coding.
We have.
We've talked about legal strategies.
And the court system.
We've even touched on global trade.
It's been a journey.
It has. And it makes you think about the future.
It does. How do we balance protecting new ideas?
With making sure technology benefits everyone.
It's a question we all need to consider.
Well, I think we've covered a lot of ground today.
We have. We've gone deep.
We've explored the technical details, the legal battles, and the bigger picture.
Hopefully it's given everyone some food for thought
Yeah.
about patents, about innovation, about the role of technology in our lives.
Thanks for joining us on this deep dive.
Thanks for having me.
Until next time, keep exploring, keep learning, and keep diving deep.